The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Tuesday, the 19th of January, 2016, are currently trading with gold at $1,087.85 an ounce, silver $14.02 an ounce, Texas crude $29.42 a barrel, and Bitcoin is currently sitting at about 375 U.S. currency. Today in history, Wednesday, January 19th, 1977, West Palm Beach reported snow for the first time on record, with snow flurries reaching as far south as Homestead and even the Bahamas. In recent news, the UN is set to set up processing centers in countries near to Central America where people will be allowed to apply for refugee status without having to pay smugglers to take them to the U.S. border. People granted refugee status may be resettled in the United States or other countries. In a recent release, the UN said, quote, "The international community is currently experiencing a flood of migrants from countries in crisis, with the number of forcibly displaced persons in the world now higher than it has been at any time since World War II. Also, according to the United Nations, almost 60 million people worldwide have been forced from their homes by conflict, persecution, general violence, or human rights violations. The global population of displaced people is growing at a faster rate than the general population." Researchers from Durham University have discovered what appears to be a massive canyon system beneath Antarctica's ice. Using satellite data, geologists have mapped out a system of canyons over 1,000 kilometers long, which is over twice the length of the Grand Canyon, with pits that reach up to a kilometer deep. They were located in the Princess Elizabeth Land region on the eastern side of the continent. The Texas Department of Public Safety, or DPS, has confirmed that a highway patrol trooper, Terry Lockridge, 33 years old, was arrested last week on charges of aggravated sexual assault of an underage girl. Mr. Lockridge has been with the DPS since September of 2009. Officials say that the case is still under investigation. The Lone Star Lowdown is currently looking for sponsors, so if you have a product or a service you'd like to advertise with us, feel free to give us a call at 210-363-2257. This has been your Lowdown for January 19th, 2016.
Received my remedy today. Came in a box, just like they say. I accepted it for value right away.
Okay, we are back. Randy Kelton, Boulevard Radio. We're talking to Scott in Texas. Kind of feel like I kind of fell into preaching that last segment. I'll try to avoid that. But it is my major pulpit. If we're going to beat these guys, we got to go after them. And once you start this process, it really changes everything, especially if you're being charged with a traffic citation. I mean, that's not a great big deal. And you get a real good experience of the legal system. Scott, as far as your experience of this ticket, you got to really learn how to go after these guys. That's not something you learn in law school even.
Well, no, and I tell you what, I got Eddie's material, a while back, probably over a year ago, so I started kind of going through and learning that stuff. And then when I submitted the motions, naturally you read them, but you don't. I didn't really pay a whole lot of attention. I read it. Okay, I kind of halfway know what I'm talking about. Okay, great. Well, when I got in there in front of the judge, I knew what I wanted to say. I knew what I wanted to do, and then I knew I was being violated. I didn't know how to address it. And then I started talking with you, and then it was like, we're going to recuse this judge, and we're going to slap him with this. We're going to file this other motion for subject matter jurisdiction, put a criminal complaint in on the top, and we'll start pointing out where all the defects are. And I'm like, defects. Interesting. So it was kind of like backtracking everything. And then once I actually did put a timeline to it, like you asked me to do, and then I could really step back and start really looking at it from an analytical point of view and really putting things together in a logical conclusion. That's when it's really started to help me. Then after reading it, it was actually that habeas that you wrote. It really seemed to put it together for me of how to use your timeline with law to make them reinforce each other, to tell a story that leads your reader to a logical conclusion that you want them to go to. And so after putting all that together and then living it, going through court, because then I had to go to jury trial because it was supposed to be going to jury trial, but I put the motion in to recuse the judge. Well, when I walked into court that morning, there was nobody in court, not even the city attorney prosecutor, whoever he's supposed to be. Nobody, just me, the judge, and the bailiff. And the judge would not say a word. He all of a sudden had a whole different attitude, and he just called me up real quietly and said, your motion to have the judge recused has been denied, and we reset this court date 4 months from now. And I'm like, yes, sir. See you later. Oh, I told him, I said, man, traffic was a bear getting here this morning. And it happened to be a foggy morning, so it was really kind of brutal. But I was just making it sound like, man, it was really tough to get here on time, but I made it.
Yeah, you wouldn't miss this for the world.
That's right. I mean, and then walk in there, and it was just like walking into a graveyard, and I was in and out in 15 minutes flat. They wanted me out of there so bad they couldn't wait till I walked out. So now
that is exactly what we want.
Exactly. So now with that said, now that I have the criminal allegation put together, I'm going to sling it on all these other judges and then walk in there. And it's going to be pretty much my backup, my last resort ammo, because as you were saying, the chances of them taking a criminal complaint with the grand jury that I'm going to indict this guy with, the judge, they're not going to take it. Okay, we can concede that's going to be a typical snafu.
Yeah, at least you hope they don't. This goes to, I have a few set rules. One of them is never make a proactive statement of law out of your own mouth. When you write a statement of fact, add, in my opinion, to the end. If the statement reads like a complete sentence, then take it out because it's not a statement of fact, it's an argument in support. And never make a proactive statement of law out of your own mouth. Once you have these down, they will lead you right to where Scott is right now, with a document that will really sting them. And once you've put one of these together, and you can go on to jurisprudence.com and read that habeas, and I have some complaints on the Cherokee County issue where you can get an idea how to structure these together. Then you can start running the routine on them. And this is where the worm turns. You flip things around and start moving it in your favor. And especially with a municipal court. The municipal judges believe that the State Commission on Judicial Conduct uses them for cannon fodder. They never discipline higher-level elected judges. But to make it look like they're actually doing their job, they crucify municipal judges and JPs. That's what they believe. And they are right. That's exactly what they do. So when you start hammering a low-level judge, they really get worried. And the more heat you bring back on them, the more they get worried. And I guarantee you, every municipal judge in that part of Texas knows what you're doing to them. They all talk to each other. I had a friend here. I knew the JP here in the town I live in. I worked him over a few times, and he was a real pro. I really like this guy. I went in one day, and he said, Mr. Kelton, you're getting pretty well known around Texas. I said, Mark, is that a good thing? No, I don't think so. He said he went to a training, a continuing education class in Austin. And when they found out he was from Boyd, they all wanted to talk about me. And I said, well, what'd you talk about? I said, well, they want to know if you were crazy. I said, what'd you tell them? He said, yeah, you are. But if he tells you something about law, pay attention. He knows his law. I said, okay, that'll work. But every time one of these JPs or municipal judges has a problem, they tell all the others about it. So the others can kind of know how to prepare. So when you start stinging them good, this starts getting around. When this judge tells all these other judges that you just filed felony tampering with a witness charge against the judge because he yelled at you, I bet you that ups his professionalism considerably. So I don't think you'll have to worry about him yelling at you next time you're in court. What do you think?
Oh, no. He's going to... What I was actually thinking is creating a criminal complaint against the cop and then going and submitting it to that court. And then once we do have to go to trial, then bring up that criminal complaint, say, hey, I got business before the court before we can proceed and have this criminal complaint, and I need you to file that criminal complaint. He's going to say no. I'm going to say the bailiff need to arrest that judge, and then just start the whole ball of fire right from the very beginning, never even make it to trial.
I don't. Okay. Probably it would be safer if you went out of the courtroom, told the bailiff to come with you.
Okay.
There's no way the judge can charge you with contempt. And if the judge says, well, we still have a hearing going on, you tell the judge, you need to hold on a moment. I have business with this bailiff. And he's likely, you don't care what he does. If the judge doesn't take your complaint, now he's committed a crime from the bench. And, if the bailiff doesn't go with you, then you tell the bailiff you need to get another bailiff, preferably to take your place in here, because the criminal complaint I want to press against this judge occurred in your sight and within your hearing. And that invokes a duty for you under 14.06. They are not going to be happy campers. Read Chapter 14, Code of Criminal Procedure. Talks about arrest without a warrant. The bailiff is the court security officer. And it is his duty to keep the peace in the courtroom. Arrest all offenders. It makes no difference who the offender is. The bailiff thinks he works for the judge. I've had bailiffs tell me that. Oh, you are mistaken. You work for me. Through the sheriff. You do not work for this judge. And if this judge commits crime from the bench in your sight and in your presence, you have a duty to arrest him. Well, I'm not going to arrest the judge. Well, life is filled with little decisions. We all get to make some. Your turn. Okay, what do you say next?
The only thing is, I guess you probably have some other callers, so I'll let you go. I want to get the couple of motions or whatever I'm going to need to get file to get the evidence of the judge, actually, because the judge, when I had that hearing, basically getting arraigned that morning out of jail, what he said is on tape. So I need to get all that evidence, and I could actually, I just need to get the records of all the case and all the audio. So I just need to get the paperwork to file the motions for that stuff. And
okay, those are you can do that with an information request. Now I have some on jurisprudence.com under documents and research, and then blanks. You pull down a blank information request. Now this is my requests are information requests. So I'm not making the request under some specified statutory authority. And this is a thing that pro se's tend to do, is they tend to give the legal system legal advice. And I suggest we don't do that. I used to have them labeled open government request. Now that implies 552 government code. So I'm changing that to open records request or information request, because you have a right to this information under more than one statute. So I don't cite any. Whatever applies. And if you cite the wrong one, they'll refuse it to you based on that, because they're going to say that these are court records. And so the Open Records Act doesn't apply. And I'll address that on the other side. Now.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Well, don't let nothing get to you. Only the Father can deliver you. So don't let bad mind people hurt you.
Okay, we are back. Randy Kelton, Real Law Radio. Call-in number is 512-646-1984. Give us a call. Call lines are open. We will be taking your calls all night. And right now we're talking to Scott in Texas. So go on, get an information request, and you'll request this from the jail. And that the jail will be, was this a municipal jail or a county jail?
Yeah, municipal.
Okay, so you'll request it essentially from the chief of police. And this is not a court record. This is administrative record. And what I was saying when we went to break, don't give them legal advice. If they ask you under what authority you're asking for this, you tell them under any authority that applies. And when they don't give it, then you cite the one that applies. 552 Government Code or 1.27, I believe. It's either 24 or 27 Code of Criminal Procedure says all courts shall be public. And under that provision, the courts are all the records are made public, except for those records applying to the adjudication of cases. Actually, they're public. I'm sorry. That applies to those records that go to the adjudication of cases. Everything else falls under open records. The administrative records of the court don't fall under 127. They fall under 552 Government Code, the Open Records Act. And for the most part, the courts don't know that. The Attorney General, he screws everything up. I'm going to be filing criminal charges against the Attorney General because they just do whatever they want to, and nobody's held them to account. I requested all the emails of a judge, and the Attorney General issued an opinion that said that the records were court records and therefore didn't have to be released, but this opinion is not for publication. You kidding me? Yeah, it is. So the Attorney General's office issued this opinion knowing it was fraudulent. That's why they didn't want it published. So they figured I'd just forget about it and go away. Well, that part's not going to happen. So now you're going to have complaint against the officer. What's the accusation against the officer?
I'm thinking I was either going to go with official oppression or aggravated kidnapping.
Okay, and that's because of in the facts of the case, I don't remember exactly how you got to that. He pulls you over for what?
He pulls me over allegedly for speeding. He has no proof. I asked him if he had a warrant. He did not. And then he basically said, if you don't give me your driver's license or an insurance, I'm going to smash out your window. 2 more minutes roll past by. He smashes out my window and grabs me and throws me on the ground, cuffs me and stuffs me.
That should get aggravated. First-degree felony aggravated assault.
Exactly, because as soon as he put his hands on me, that was assault.
Okay, first-degree felony aggravated assault, false imprisonment, or false imprisonment. That's about it for him. He did charge you with not having a license, but he found that later, and he can do that.
Correct.
But then you claim in that case that you claim under Fruit of the Poison Tree that you were subject to a false arrest, and this evidence for this last offense was not discovered until you were falsely arrested. So therefore, it's Fruit of the Poison Tree. They can't use it in court.
Right. That's what I'm working on right now. So as soon as I get it drafted up, it's actually turned into a quite lengthy document already.
And there is a chance in Dallas County that the Dallas County District Attorney may get that complaint to the grand jury, because I filed criminal charges against the past Dallas County District Attorney with the Tarrant County District Attorney. And the allegation is that the Dallas County District Attorney had me removed from the courthouse to keep me from filing criminal complaints with the grand jury.
Ooh.
Yeah. So the DA knows that I filed these, and she's not going to want me filing the same thing against her, especially now with all the heat she's under. So once you stack up a couple of judges, and if I were doing this, I'd want to stack up them all. You work your way all the way up to a district judge and get a district judge to refuse. You could even go to the appellate courts and send them to each of the appellate court judges and get them to refuse, and then send them to Supreme Court, primarily the Chief Justice of the Supreme, and then take complaints against all of these people to a grand jury. Take these guys for shielding from prosecution, official oppression. each one that refused to act on a complaint. And we haven't went over this in a while. When you signed the citation, on as an agreement to appear before a magistrate. At 543, do you remember the numbers on that, Scott?
No.
Okay, 543-006, I believe. Authorizes an officer when he writes a citation on a Class C misdemeanor violation of the Transportation Code. The officer is authorized to allow the person arrested to sign a promise to appear before some magistrate of the county. That's what the code says. It does not say before some judge of the county. It says some magistrate of the county. So you signed that and you agreed you were under contract to appear before some magistrate of the county. You came to court and asked for an examining trial, and it was denied because the judge was acting in the capacity of the trial judge and not as a magistrate. This is what happened in, this always happens in every whole examining trial. I had a speeding ticket in Azle, Texas, and went to court. Judge called me up, and I had been there before, and I walked up to the bar, to the bench, and I looked down at the name tag, and I said, Judge Dedman. I seem to remember a Judge Dedman in Azle, but I don't remember him having that much gray hair. And the judge looked to me and said, yes, Mr. Kelton, I don't remember your belly being quite that big. Oh, well, touche. And he said, well, Mr. Kelton, how do you plea? I said, well, Your Honor, I'm not here to plea. I'm here to have an examining trial, and I want you to hold one. No, Mr. Kelton, I'm not going to hold an examining trial. Well, in that case, I want you to get the bailiff to come over here and arrest you for Class A misdemeanor official oppression, criminal violation 3903 Penal Code. No, Mr. Kelton, I'm not going to have the bailiff arrest me. Well, then let's see if we can get the prosecutor to do it. The prosecutor, I'm not going to do it. They thought I was just screwing around with them, but I wasn't. I was setting the record. Now, it's not a court of record, but I got a whole room full of people. And they'll admit that they refused to arrest a judge. The judge was not there in the capacity of a judge. Judges wear two hats. They wear a judge's hat and they wear a magistrate's hat. When a criminal accusation is made before a magistrate, before a judge, the judge is sitting in the capacity of a magistrate, not a judge. These municipal judges don't understand this. This guy thought he was really a judge, and he's been an attorney forever. And it goes to show the attorneys do not know the law. Hang on. Randy Kelton, Wheelbar Radio, or call-in number, 512-646-1984. While we're on break, go have a look at our sponsors, and we've got our fundraiser going. See if you can help us out and keep us on the air.
Okay, take a right turn at the gas station, then go 2 blocks, turn left on Main, and it's the third house. Oh, hi! Catherine Albrecht here, giving driving directions that involve left turns, while I still can. Details coming up.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
A superstreet is a road where the left-hand turns are rerouted. Drivers instead have to make a right turn and then make a U-turn around a broad median. Well, this may seem silly and time-consuming. Research shows a 20% overall reduction in travel time compared to conventional intersections. What's more, superstreet intersections have nearly 50% fewer reported automobile collisions and 63% fewer cases of personal injury. The superstreet concept has been around for over 20 years, but until now, little research had been done to assess its effectiveness under real-world conditions. Given the latest data, left turns may soon become an endangered species. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Live Free Speech Radio, LogosRadioNetwork.com.
Okay, we were back. Randy Kelton, Wheelbar Radio. I think we've kind of handled everything here. Scott, do you have anything else for us?
No, sir. I'll let you get to everybody else. And just all y'all out there listening, put some effort into this and do a little studying. It'll pay off big time. So other than that, I will let you go, and you have a great evening, sir, and I will talk to you soon.
All righty. Well, right now the call boards are open, but I don't have any callers, but I did have something I wanted to go to. I pulled it up yesterday, but I didn't have time to get to it. It is a treatment I did. I'm looking at, there we go. Governor Perry. This goes to grand jury. And this is a treatment in paramateria. Paramateria means how everything fits together. If one thing is in paramateria with the other, then it fits within the structure. Everything fits within the structure together. And I wrote in the Tom DeLay case, I wrote a habeas corpus and filed it. And it went to these proceedings. But this one was a little more complete that I sent to the governor's lawyers. And I don't know that they ever acted on it, but I did want to kind of go through this. It's real technical, real specific. And it's kind of an examination of Chapter 19, 20, and 21 of the Texas Code of Criminal Procedure. I'm just going to read the letter, probably the best way. In your habeas corpus, you're trying to change law. They filed a habeas corpus. And the arguments they were making were arguments that the law they were addressing didn't apply in this case. And they were trying to get a distinct on case law, but they didn't address the right issues, and that was my point. Steep hill to climb when the prosecutor had to circumvent the clear dictate of the legislature in order to get this bogus indictment. I realize this may sound presumptuous since I'm only a radio talk show host and not a lawyer, but the code in this case seems very clear. The governor, like every other citizen, had a right to the due course of the laws that was deliberately circumvented for this political assassination. Now, I'm no fan of Governor Perry, or ex-Governor Perry. I'm a fan of due process, and they didn't follow it. The legislature very clearly intended that a prosecuting attorney not have the power to seek an indictment in secret. Provision was put in place to prevent a prosecutor stacking a grand jury by granting any person the right to challenge the grand jury panel prior to impanelment by the inaction of Texas Code of Criminal Procedure 19.27, which reads as follows. Any person may challenge, before the grand jury has been impaneled, any person may challenge the array of jurors or any person represented as a grand juror. In no other way shall objections to the qualifications and legality of the grand jury be heard. Any person confined in jail in the county jail shall, upon his request, be brought into the court or make such challenge. Okay. To further prevent secret grand jury, the legislature enacted a specific prohibition against the seeking of an indictment prior to giving notice that she or he may have need of availing himself of the right granted by Texas Code of Criminal Procedure 19.27 Supra, by the enactment of Texas Code of Criminal Procedure 16.01, which reads as follows. Examining trial. When the accused has been brought before a magistrate for an examining trial, that officer shall proceed to examine into the truth of the accusation made, allowing the accused, however, sufficient time to procure counsel. In a proper case, the magistrate may appoint counsel to represent an accused, and in such examining trial only to be compensated as otherwise provided by this code. And here's the part that matters. The accused in any felony case shall have the right to an examined trial before indictment in the county having jurisdiction of the offense, whether he be in custody or on bail, at which time the magistrate at the hearing shall determine the amount of sufficiency of bail if bailable. Everyone has a right to indict to a examining trial before indictment. And this is further addressed in 2022. This right was further bolstered by the enactment of Texas Code of Criminal Procedure 20.22, which reads as follows. Presentment entered of record. The fact of a presentment of indictment by a grand jury shall be entered in the record of the court if the defendant is in custody or under bond, notifying briefly the style of the criminal action, the file number of the indictment, and the defendant's name. Let me go back and address something there. The fact of a presentment of indictment by a grand jury shall be entered in the record of the court if the defendant is in custody or under bond, notifying briefly the style of the criminal action, the file number, and the defendant's name. If the defendant is not in custody or under bond at the time of the presentment of indictment, the indictment may not be made public, and the entry of the record of the court relating to the indictment must be delayed until the capias is served and the defendant is placed in custody or under bond. Now, it says until the capias is served. And the, meaning one previously mentioned, refers to 21, where it instructs the clerk of the court, if the person named in indictment is not in custody, to issue a capias. Well, according to by this, there can be no indictment until the person has had an examining trial. This assures that because it forbids the court to record the indictment until the person's been arrested. When a person is arrested, the arresting officer is directed to take the person directly to the nearest magistrate. Now, if you read if you read a warrant, what a warrant says is you are to arrest this person and bring him before me. So when a warrant is issued, it is issued for the purpose of bringing the person before a magistrate, not for putting him in jail. They have to bring him before a magistrate, whether he's arrested with or without a warrant. If a warrant was issued, the warrant was issued ex parte. The only reason they would need a warrant is because the other party's not there. So it's necessarily an ex parte issuance. And once it's issued, it says, bring that person before me. And bring it before me, the magistrate who issued the warrant, is because they held an ex parte hearing. Once the person is arrested, they're to be brought back before the magistrate, and another examining trial is held with both parties present, so that the arrested party or the accused is accorded all of his rights. This is required to happen before an indictment. What happened in this case was there never was a criminal complaint. Nobody ever accused the governor of anything. So even if the prosecutor is required, when he receives a criminal complaint, he's to reduce the complaint to an information. If the complaint alleges a crime by a public official, he must reduce the complaint to an information submitted to the grand jury. He doesn't get to investigate into it. He just gives it to the grand jury. And he's to submit the complaint to some magistrate. We're about to go to break. We'll talk about that when we come back on the other side. This is Randy Kelton, Rule of Law Radio. We've got our fundraiser going, so while we're on break, go have a look at Logos Radio Network and look at our gun giveaway. We've got a couple of gun giveaways and some vapor, some other stuff. So go have a look. Help keep us online. We need all the help we can get. We'll be right back.
Easy.
Okay, we are back. Randy Kelton, Rule Radio, and we're talking about how the grand jury, how indictments are supposed to be brought. In this case, we go to Trussell. In 1967, Trussell rendered void all of the above and had the effect of ruling that if a prosecutor does what he or she is specifically forbidden to do by secretly presenting to a grand jury a person who has not been afforded the right to an examining trial, that said violation denies the accused in rights specifically granted by statute. Without any points or authorities or explanation, the court simply ruled out of hand that a prosecutor can act in violation of 3903, which reads as follows. 3903 Penal Code, Public Servant Act, under color of his rights, of color of his office or employment, and color in this case, says the term of art means pretense, commits an offense if he intentionally subjects another to mistreatment or arrest, detention, search, seizure, dispossession, assessment, or lien that he knows is unlawful. I won't read the rest of it. That's the one that's relevant. In the instant case, it had to be clear to the presiding judge that the indictment had been presented to the court in violation of Texas Code of Criminal Procedure 20.22, what we read earlier, that the prosecutor had presented to a grand jury wherein the person the prosecutor intended to seek an indictment of was denied the right granted in Article 19.27. The violation of Article 20.22 and violation of 19.27 were accomplished by violating the specific denial of the right to an examining trial in violation of Article 16.01. No reasonable person of ordinary prudence can read Article 16.01 and construe it as anything other than a prohibition on the prosecutor from seeking an indictment until the accused has been given the opportunity to present exculpatory evidence. This exculpatory evidence would then be available to any subsequently impaneled grand jury under the dictate of TCCP, Texas Code of Criminal Procedure 2.01, which reads as follows. Duties of district attorneys. Each district attorney shall represent the state in all cases in the district courts of this district and in appeals therefrom, except in cases where he has been, before his election, employed adversely. When a criminal proceeding is had before an examining court in his district or before a judge on habeas corpus, and he is notified of the same and is at the time within his district, he shall represent the state therein unless prevented by other official duties. It shall be the primary duty of all prosecuting attorneys, including special prosecutors, not to convict, but to see that justice is done, and this is the part that matters. They shall not suppress facts or secret witnesses capable of establishing the innocence of the accused. By seeking an indictment prior to presenting the complaint to some magistrate, securing a warrant and arresting the person and holding an examining trial, they deny the person the opportunity to present exculpatory evidence, which is supposedly guaranteed by 2.01. So in doing so, he also violates 2.01. Had the governor been granted the due process of the laws, the evidence you put in your habeas corpus filing would have been available to the grand jury and no indictment would have happened. If you follow the case law, it will be clear that everything evolved from Trussell. Trussell, as a precedent, is worthless. There were 3 cases. The prosecutor cited one case, and that case relied on another case. The second case relied on Trussell. And in Trussell, the guy complained that he wasn't given an examining trial. And the judge said, after you're indicted, you can't get an examining trial. The argument was, you can't get an indictment until there is an examining trial. So the judge just arbitrarily and capriciously blew it off. The governor to all the people who voted to fight this travesty and breach of due process. Get this garbage case law thrown out and the rule of law returned. As far as I can tell, they did nothing. And I ended with, that's my story, and I'm sticking to it. This is, the governor's case here is essentially what caused the legislature to write new law. At the time this occurred, the Travis County District Attorney's Office had a public integrity unit. And Ron Earl had gotten that put in. And Ron Earl used that public integrity unit to prosecute Tom DeLay. Tom DeLay, the second highest level public official in the country, Speaker of the House, was taken out by Travis County District Attorney illegally. Nobody ever filed a criminal charge against Tom DeLay. If you look in the record today, there's none in there. I filed a habeas corpus in the case. Dick DeGuerin, his lawyer, called me and said, "Are you the one that filed the habeas corpus?" I said, "Yes, I am." He said, "Well, I'm the lead attorney, and I didn't authorize it." I said, "Authorize it? You're the one that should have filed it." And he got a little huffy and hung up on me. So when they went to trial, they came in the morning, they picked a jury. The jury went out for lunch. They came back, and Judge Dietz was talking to the jury, and I stood up in the courtroom and said, "Your Honor, my name's Randall Kelton. I have business with this court that supersedes any business now before this court." And the judge said, "You're the one with the habeas." I said, "Yes, as a matter of fact, I am." And he said he wasn't going to waste the grand jury's time with this nonsense. Now, I had put that habeas in Tom DeLay's hand, and he did nothing with it. The judge ordered me out of the courtroom, and I'll be back after the judge for that. But they arrested, they found Tom DeLay guilty. They put him in jail. He spent 3 years in jail waiting for the appeal, or he got 3 years, and he spent however long it took to get the appeal. And the appellate court dismissed the case for lack of evidence. So Tom DeLay gets out of jail with no conviction on his record. I looked at that and said that had to be an arranged deal. That was all set up. I think when I put the habeas in Tom DeLay's hand, I probably terrified him because he had a lot of dirtier stuff going on in the background. And he had made a deal to keep from having to spend the next 20 years in jail, and he was looking at me possibly screwing up his deal. But the whole thing was illegal. It was exactly like what they did in the Perry case. And after Tom DeLay and then Perry, if you look in the record in Rick Perry's case, you'll find the criminal complaint there either. They're prosecuting these people, and nobody ever accused them of a crime. So the legislature, Ron Earl, the Ron Earl, the Travis County District Attorney, had lobbied for and got legislation to fund these public integrity units. And at the last legislature, they passed a new law that transferred the investigation of public officials to the Texas Rangers. Now, I'm trying to get a hold of the Texas Rangers. They had until September to put together a set of rules and procedures for investigating public officials. Prior to this, the statutes, the policy of the public safety was that a Texas Ranger could not take a complaint against an official and could not even investigate a public official without the express permission of the director of the Department of Public Safety himself. The Texas Rangers are a part of the Department of Public Safety. Now we have a special unit just for this purpose. And I intend to be giving them some really interesting cases to work. One of the hardest parts I'm having here is I have so many criminal complaints to make. I'm having to work at how to structure them so that they lead inevitably to a conclusion of an ongoing criminal conspiracy on the part of Texas to obstruct justice and deny due process. It's one of those issues where I have a lot more complaints than I can actually file. I've got so many for so many different things that the only way I can effectively file these is in a manner that the cases demonstrates an aspect of essentially a RICO suit. But I want to file this in the form of a criminal conspiracy against most all the public officials in the state of Texas, at least all of the ones that I have filed complaints with and they failed to act. Those I can charge directly. And if we get enough of them, odds are they're going to want a sacrificial lamb and they'll throw somebody under the bus. And I'm hoping it's the Chief Justice of the Supreme, but I probably won't get him. The Attorney General, the Governor, the ex-Attorney General, maybe we'll get one of them. We're sure going to take our best shot. Randy Kelton, Rule of Law Radio, our call-in number, 512-646-1984. Call boards are open. Give us a call. We'll be right back.
process when it comes to taking his place. I will lock my
Like a thief in the night, I saw the father enter. Chase all the parasite from around her. Thief, liar, and even murderer. Chase them out the house because them cannot enter. Pure in heart and clean hands only. Only them could enter in God's house, you see. See abuse souls surrender quickly. That's what we are doing now. We have the house, you see.
I will occupy my father's house. Won't allow the wicked to come and keep me sleeping, still the truth. My soul along with it.
Okay, we are back. Randy Kelton, Rule of Law Radio. And our call-in number is 512-646-1984. Call lines are open. At least I think they're open. Let me make sure they're open in case, because we don't have any calls, and generally calls pick up late in the evening. Maybe I put everybody to sleep today. Well, okay, this is, since I have an open hour, I'm going to take advantage of it and go through my original habeas on due process. I haven't done a due process presentation in quite a while, so I'm going to go through the habeas and kind of do due process. If you've been arrested in most any state in the union, but especially Texas, I've done seminars all over the country and looked at the code of a number of different states and then compared the codes to the practice. And in every state I've looked at, it's been essentially the same. If you are accused of a crime, and I'll speak to Texas because I have precise statistics for Texas. If you're accused of a crime in Texas, you are going to take a deal. And that's all there is to that. You're going to take a deal because every step is presently practiced from arrest to trial has been very carefully structured so as to any person accused of crime in a position such that when the prosecutor comes to them and offers them a deal, they have no reasonable option other than to take it. And that is because every step from arrest to trial is not only wrong, it is very specifically against particular law. And it's not just against particular law. It's against particular law for a very specific purpose. Everything is designed to force you to take it. And several years ago, I wrote a habeas for a kid in Conroe. I had the Republic of Texas come to me, and the president and the attorney general for the Republic of Texas. And they wanted me to see if I could do something to get this kid out of jail. The kid was picked up for DUI, and he had been in jail for, I think, 28 days at this point. And these guys from the Republic of Texas have been telling him all this stuff to do. And by this time, the Republic of Texas group had filed so many liens against public officials, they had the whole state of Texas ready to shoot them all. I think they eventually put the president in jail. But I looked at what they were doing, and I was furious. I told those two, you guys need to go sit your behinds down there in jail and quit telling this kid to do this stupid stuff you're having him do. He refused to talk to him. He was filing some documentation they told him to file, and I looked at it, and it was all from a legal form guy's perspective. These documents were rubbish. So I prepared this habeas, and the habeas starts out with the premise that if a person is arrested, that is a big deal. I know the police don't think it's a big deal because they do it all the time. But the courts have held there are few more horrifying experiences than that of being suddenly snatched from a peaceful and ordinary existence and placed in the helpless position of having one's liberty restrained under the accusation of a crime. Hollingsworth - Abbott County v. Hodge, Oklahoma, 175. I don't have a date on it. So the courts, at least some of them, consider that being jerked out of your orderly life and arrested is a really big deal. In endeavoring to, now we get to once an arrest is made, there are certain things that the arresting officer must do. I'm going to Robinson v. Lavelle. In endeavoring to take the arrested person before a magistrate, the officer must expend all the effort that a highly cautious person would employ in the same circumstances. Once a person is arrested, and I don't know why I missed it in my statement, under 14.01, an officer can arrest someone for any offense in his sight or in his presence. That's 1401B. 1401B was put in 1965, and that is the paragraph that turned the state of Texas into the worst police state the world has ever seen. Prior to the enactment of paragraph 1401B, paragraph 1401 said a person could be arrested for any offense that was a breach of the peace or felony. It restricted, without a warrant, to breach of the peace or felony. 1401B changed that to make it so that an officer can arrest you for anything. Dropping a cigarette on the sidewalk, looking at him crossways, anything. And once the arrest is made, Article 14.06 Texas Code of Criminal Procedure directs the arresting officer to take the person arrested with or without a warrant to the nearest magistrate. 14.06 must take the offender before the magistrate, except as provided by subsection B. In each case enumerated in this code, the person making the arrest or other person having custody of the person arrested shall take the person arrested or have him taken without unnecessary delay, but not later than 48 hours after the person has been arrested, before the magistrate who may have ordered the arrest, before some magistrate of the county where the arrest was made without an order, or, if necessary, to more expeditiously to the person arrested, the warnings described in Article 15.17 of this code, before a magistrate in a county bordering the county in which the arrest was made. The magistrate shall immediately perform the duties prescribed in Article 15.17 of this code. This last portion, referencing 15.17, this was added, I'm not sure when, at some time later. Chapter 15 goes to arrest on a warrant. So based on that, 1517 should only apply to arrest on a warrant. And it requires the magistrate, it says the magistrate shall immediately perform the duties described in 1517, and that's to read the person their rights. And the courts have read this to overturn 200 years of law, to say that now you don't have to do any of the stuff in all of Chapter 16, that this little addition to 14.06 has the effect of negating Chapter 16, a whole chapter, that all you have to do now is read somebody their rights. You don't have to hold an examining trial. Well, when considering the lawfulness of a warrantless arrest for the purpose of jurisdiction, this particular argument will only consider the actions subsequent to arrest. The immediate issue addresses the duty of the arresting officer to take the accused before a magistrate to secure jurisdiction such that the state may rightfully continue to restrict relator at liberty. And in a habeas, the one filing the habeas is relator. Maximum protection. This is Gerstein-Pugh. Gerstein-Pugh is a federal case. Where's it at? Southern Court. Maximum protection of individual rights could be assured by requiring a magistrate's review of the factual justification prior to any arrest. But such a requirement would constitute an intolerable handicap for legitimate law enforcement. Thus, while the court has expressed a preference for the use of arrest warrants when feasible, Beck v. Ohio, it has never invalidated an arrest supported by probable cause solely because the officers failed to secure a warrant. See Kerr v. California. Under this practical compromise, a policeman's on-the-scene assessment of probable cause provides legal justification for arrest of a person suspected of crime, and for a brief period of detention to take the administrative steps incident to arrest. Once the suspect is in custody, however, the reasons that justify dispensing with the magistrate's neutral judgment evaporate. There no longer is any danger that the suspect will escape or commit further crimes while the police submit their evidence to a magistrate. And while the state's reason for taking summary judgment action subside, the suspect's need for neutral determination of probable cause increases significantly. The consequences of prolonged detention may be more serious than the interference occasioned by arrest. Pretrial confinement may imperil the subject's job, interrupt his source of income, and impair his family relationships. This is okay. Even pretrial release may be accompanied by burdensome and burdensome conditions that effect a significant restraint of liberty. When the stakes are this high, the detachment of a neutral magistrate is essential if the Fourth Amendment is to furnish meaningful protection from unfounded interference with liberty. Accordingly, we hold that the Fourth Amendment requires a judicial determination of probable cause as a prerequisite to extended restraint of liberty following arrest. Gerstein Pugh, Southern Court. Hey, when someone is arrested in Texas, they always go to break.
This is the Logos Radio Network.
Oh, come on.
Okay, we are back. Randy Kelton, Rule of Law Radio. And we're talking about due process. Once the person's been arrested, the federal law requires an examining trial. We don't get examining trials at all in Texas after the inclusion of into 1406 of this reference to 1517. I know that can get confusing. But the law has been pretty consistent for a very, very long time. Let me move ahead. While certain delay may be expected in certain circumstances, simple failure to seek the authority envisioned by Gerstein Pugh above may not be construed as a proximate cause of reasonable delay. The seminal case on this under Texas state law is Heath v. Boyd. Heath v. Boyd's kind of a fun case. Moreover, if Heath's arrest had been authorized, let me explain Heath. Heath is operating a road grader. This is a 1920. I'll find it here. This is a 1920-something case. He's operating a road grader, cutting a road, and this guy come out and said, "Hey, that's my property. You can't cut that road there." And the guy said, "Well, my boss told me to cut this road, so I'm cutting the road." So the guy tells him, "You either quit cutting that road, or I'll call the sheriff and have you arrested. You're going to have to call the sheriff because I'm not going to quit cutting the road." So he calls the sheriff. Sheriff comes out and tells him to quit cutting the road. He says he's not going to quit cutting the road. So if you don't quit cutting the road, I'll arrest you. He said, "Well, you have to, because if I quit cutting the road, the boss will fire me." So he arrests him. He takes him from wherever the arrest was, 26 miles to Corpus Christi, and held him for 45 minutes. And the sheriff talked to the guy's boss, and they worked something out, and the sheriff told him he could go. He sued the sheriff for false imprisonment because there was a magistrate in a town 6 miles away from where he was arrested, and the sheriff didn't take him to that magistrate. Okay. Moreover, if Heath's arrest had been authorized by the statutes, his subsequent detention, as pleaded, proved would make a case of false imprisonment against Boyd. The undisputed facts are that after his arrest, Heath rode with the sheriff to the former's car, which he then entered and drove several miles to the courthouse, followed by Boyd. There he was detained in Boyd's office from 1 to 3 hours. While Boyd was seeking advice by telephone as to what to do in the face of a plain statutory command as to what must be done in all cases of arrest without warrant. Article 217 CCP 1925 provides in each case enumerated in this chapter, the person making the arrest shall immediately take the person arrested before the magistrate of the county where the arrest was made without an order. Substantially the same requirement appears in Article 325. Now, okay, Article 325 of the 1925 Code. It's important in Texas to understand the 1925 Code. The 1925 Code is the code, and no subsequent code can affect a substantive change of the 1925 Code. And this is an argument we can make on 1406 above, that adding 1517 to 1406 made it violate which one? I lost my place. Okay. made it violate it substantially changed the 1925 code, which they're not allowed to do. Presumably there was a magistrate in Murtaugh, the county seat, yet Boyd offers no reason why he did not take Heath before that official. Neither in his pleadings nor in his testimony does he suggest that a magistrate was not reasonably available. Although the arrest and detention all occurred between 8 o'clock in the morning and noon, if he had taken Heath to that official, he could have gotten the information and assistance he was seeking by telephone. He was under no obligation to seek advice or aid from Johnson. He was under a positive duty immediately to seek a magistrate. That such failure, unexcused, makes a case of false imprisonment as a matter of law is held by all authorities. And I think the sheriff had to pay $500. The arresting officer in this case made no due diligent effort to locate a magistrate. And this is what always happens in Texas. At every other state I've looked at, if you're arrested, you're taken directly to jail. The next case, although the failure to take the plaintiff before a magistrate would have been excused if good grounds had existed for the belief that a magistrate was not available, such was not the case since the defendant's officers made no attempt to determine whether the magistrate was or would make himself available. Roberts v. Bohack. So the only defense an officer will have against a complaint of false imprisonment for failure to timely take before a magistrate is a showing of due diligence and effort to locate. Every time I've been arrested, the first thing I did was requested from the arresting agency a list of all magistrates in the county and all of the magistrates in all surrounding counties, or in all adjacent counties, because that's what the statute says. The statute says you must take the person arrested before some magistrate of the county or some magistrate of an adjacent county. So I asked them for a list of all the magistrates. I always get the same answer. We don't keep such a list and we're not required to prepare one. Perfect. It's exactly what I need. And that establishes that no due diligent effort was made to locate a magistrate under Roberts v. Bohack because they don't even know who the magistrates are. Okay. Irrespective of any other state, Texas has specific information concerning this requirement to take the accused before a magistrate. Not only must the arresting officer exhaust the available magistrates in the county, the consideration of the availability of the magistrate must be extended to include every surrounding county. See Texas Code of Criminal Procedure 14.06. Supra. Supra in case law means that it's been cited above. The record offers, and this is United States v. Colon, the record offers, as the government's only justification, evidence that the magistrate who issued the warrants advised of his unavailability after the early evening of Friday, September the 8th, 1989. There are 3 other magistrates in the district. The record is bereft of any evidence as to their availability. Likewise, the record is bereft of any evidence as to the availability of any of the district judges. Absent evidence of other than the unavailability of the duty magistrate, the proprietary, that doesn't make sense. The proprietary of which is not here questioned. There is no basis to find that the delay of the entire period from the arrest to presentment was necessary. To be sure, it was a weekend. The court was closed, but those facts do not entitle the government to presume the absence of an obligation to try to arrange the appearance of an arrestee before one of the other possible judicial officers. The law requires the law remains a force in life even outside usual business hours, and all judicial officers have the obligation to respond to the needs of party as they are mandated by the law. Related to their relationship non-judicial activities, all judicial officers stand ready to fulfill that obligation. Here the government has not shown the unavailability of all the possible judicial officers. The obligation of complying with the law lies with the government, which thus has the burden of proving that an arrestee was brought before a judicial officer without unnecessary delay. Its proof of the unavailability of one judicial officer does not prove that the delay to the next regular business hours, some 60 to 65 hours later did not constitute unnecessary delay if it does not exhaust the break time. We'll be right back.
Fishing is a wonderful pastime. It's a terrific way to bond with family and get in touch with nature. But there's a scary kind of fishing you'll want nothing to do with. I'm Dr. Catherine Albrecht, and I'll tell you more in just a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Phishing, spelled with a PH, isn't very sporting. The goal is to reel in personal information and compromise your account. The PH in phishing stands for phony. Phishing scams involve impersonating legitimate organizations like banks, and the bait is usually a phony email. A phishing email may ask for account information or provide a link to an official-looking website, but don't fall for it. Never email your bank account number, your user ID, or passwords. Legitimate companies won't ask you to, and it's best to enter a website address directly rather than clicking on an email link to check an account or make a purchase. Accidentally typing data into a phishing website could cost you thousands. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Chemtrails. You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Google Law Radio. And there's one, we've got a couple of callers now. So there was one more case that I wanted to read here. I've got some really nice cases in here. Merely being arrested is for most persons an awesome and frightening experience, an invasion of considerable proportion. Even routine traffic stops made by the state trooper can intrude on the privacy of the individual. A search may cause only annoyance and temporary inconvenience to the law-abiding citizens, assuming more serious dimension only when it turns up evidence of criminality. An arrest, however, is a serious intrusion regardless of whether the person sees is guilty or innocent. The invasion and disruption of a man's life and privacy which stem from his arrest are ordinarily far greater than the relatively minor intrusions attended a search of his premises. Okay, I've got a bunch more. I'm on page 18 of 47. So I have two callers and only got 2 segments left, so I'm going to have to stop on this one. I need to set aside time in another show to go through this whole document. This is primarily, while it's written for Texas law, primarily my citations are federal law, and the states all have to abide by these requirements. So from the look of this, we need to sue the state of Texas for RICO. Okay, we're going to go to calls. Going to go to Oliver in Tennessee. Hello, Oliver.
How you doing, sir?
I hear you have a question for us.
Yeah, I have 2 questions. I've been listening to the Eddie Craig show. That's how I know of you. And I've been using his technique on the criminal side, but I've also, through that understanding, I've been learning about, private property and other laws. And my thing that I have right now is with the codes department. I've had a fire recently, and now the person is saying that I have to demolish the home and get building and permits and all this stuff. And
wait a minute. You have a what? Did you say a sign?
A house fire. I just had a house fire recently.
Oh, a house fire. Okay.
Yes, house fire. So so now they're threatening to come in and knock down the rest of the building, saying that it's condemned and it's a hazardous.
Okay. Hold on. How long has it been since you've had the fire?
September.
And the city's already trying to condemn your property. Why does the city want your property?
They don't want the property. They want to knock down the building, or for me to knock down the building.
Why do they want? No. This is too soon for the city to be stepping again. Is your property in a location where the city might want to secure the property?
No. The thing is, they were trying to enforce codes on me before the fire happened. And with the understanding of the law that I came to have, I told them no. I basically did not apply with whatever their ordinance was, and they were very upset about it. They tried to take me to court, I didn't go to court.
Okay, hold on. Is the building in danger of falling down?
No.
Secure? Do you have windows or boarded up windows and doors on it?
Mm-mm.
Wait a minute. You have to speak. You can't. I'm having trouble even when you speak. Did you say yes or no?
No, sir.
No. So that means okay. So it's not closed up where the kids can't get into it.
No.
Okay, that may be part of their problem. You need it closed up because it will stand as a hazard to the kids in the neighborhood. But did they come to you and notify you of what they wanted you to do and what the law was that authorized them to make the claims?
Mm-hmm. Yes, sir.
How much time did they give you?
I think it was like 30 days or something like that.
And what did they require you to do in those 30 days?
They wanted me to demolish the standing structure.
Okay, so they have already condemned the property?
Yes, they have.
Okay, was there a condemnation hearing?
No, not that I was aware of. They didn't condemn the whole property, just the building. It just what they're saying is they're concerned about the building, and well, I guess the stand that I was standing on, well, it's private property.
Well, it sounds like what they're trying to do is prevent you from repairing the building. Do you intend to repair the building?
Yes.
Okay. Did you have insurance on the building?
No, not at the time. Sorry, no.
Can you show that you have funds to repair the building, or you can secure funds to repair?
Yeah.
Then petition the court for a restraining order. In Texas, it costs $15 to apply for a restraining order.
Against who?
Against the city. The ones who are trying to get you to force you to tear your building down.
All right. Yeah, all right. Cool.
And if they condemned your property without a condemnation hearing, then you, or even if they had one and didn't give you notice, then you move to have the condemnation hearing reversed and move for a restraining order to prevent them from interfering with your property until you have time to bring it up to code. At least that's the way I do it. Restraining order is not that terribly difficult.
Okay, so even though I'm in private, I have private property, and I'm in the city, I still have to follow codes. I still have to abide by.
Oh yeah. If you have a property in the city, you'll have to follow code. I know there are guys who say, "Well, you're not under contract." They have to prove that you entered into a contract with them. Horse manure. While you're trying to do that, they'll tear your house down. So I wouldn't suggest that you take on any arcane first blush issues.
Okay.
If they've already condemned your property, you have to get the condemnation overturned. And if they had a condemnation hearing and you weren't noticed, unless there's some peculiar statutes in Tennessee, I know Tennessee's full of hillbillies, and you know how hillbillies are.
Mm-hmm.
I know how hillbillies are because I'm from Tennessee. I'm just teasing there, but you need to make sure there's not some specific statutory authorization to condemn without a public hearing in certain circumstances. If there's not, then you had a right.
See, the thing is, even if I do go by their rules, it still doesn't meet the qualifications to be torn down. I have a fire report that says that how much of the house and percentage is burnt.
Oh, okay. Now that changes things.
Right. It doesn't even mean. I wasn't trying to.
Okay, hold on. Have you read the penal code for the state of Tennessee?
The penal code.
Yeah.
Can you,
yeah. You have a penal code for Tennessee.
Penal code. Okay.
It has the criminal laws in it.
Okay.
One of which is going to be a law that reflects 18 U.S. Code 242. Every state has a statute that essentially says that if a public official exerts or purports to exert an authority he doesn't expressly have, in the process denies a citizen the full and free access to enjoyment of a right, that's a crime. It's Class A misdemeanor in Texas.
Mm-hmm.
Next thing to a felony. Same with the feds, probably the same in Tennessee. So if you need to look at whatever reports were presented to the city by code enforcement to authorize or to propose condemnation. Mm-hmm. If the report has statements in it concerning the building that are not true. And if the building does not meet the requirements for condemnation, their document's going to have statements in it that are not true.
Gotcha.
That's tampering with a government document, and that's felony in every state. So you go after whoever did that as a felony, and then you move to strike his document based on the, I'll think of the term, trespass ab initio. I'll speak to that when we come back from break. Randy Kelton, Rule of Law Radio. We'll be right back.
Easy.
Okay, we are back. Randy Kelton, Rule of Law Radio. Oliver, you apparently haven't listened to our show very much, so you probably aren't really aware of the approach we take.
Okay.
And our approach is that all of these guys who work for code enforcement, they are public servants.
Yeah.
You are the master of the servants. So when I authorize my public servants to perform a function, I set for them specific guidelines. And one of the guidelines is always that they must act in accordance with all law. We do not authorize our public officials to violate our laws. So if a public official placed on a document a statement that your property requirements for condemnation, when your property did not meet the requirements for condemnation, that is tampering with a government document. And that's a felony in most every state. While you have the option of suing him, suing and filing criminal charges have nothing to do with each other. What the public officials will want you to think is that if you sue them, you can't file criminal charges. Horse manure. If you have knowledge that a crime has been committed, you have a duty to report that crime. Doesn't matter whether you sue him or not. So these guys are coming after you. This is a good time to introduce them to the deep end of the pool.
Well, I heard a few of your shows. When I went, they actually called me down to City Hall to have a meeting with the city attorney and the codes director and a few of the employees. And I actually got them on tape lying, saying that because are they allowed to come on my property and take pictures of my backyard? I have a tiny house in the back. They got pictures of my tiny house.
Wait a minute. They have restricted your access to your property?
No, they didn't restrict it, but they came on there and took pictures of all over on my property.
Did they have a warrant when they came onto the property?
No, they didn't. They didn't have no warrant, no anything.
I got people that claim that is an illegal taking.
Yeah, I know. That's why I know that. I was trying to figure out how to sue them. I was trying to look.
Okay, I'm going to suggest too soon to sue directly. If you sue for anything, sue for a restraining order. Sue for a restraining order, then ask for pre-litigation discovery. First, you get them stopped. And if you plan to repair the property anyway, you sue for the restraining order to give you time to fix the property. And then while you're working on the property, then you start hitting these guys with open records requests first.
Open records?
Because they're easier. And if they give you any crap on the open records, then you go back with discovery. Okay, here's how it works in a lawsuit. If you file suit against the city, you're going to lose.
Okay.
Yeah, that may not be nice, but in the real world you and I live in, that's how it works. Courts are corrupt. They're absolutely corrupt. And if you're a pro se or a little guy against the city or deep pockets, they're going to rule against you out of hand at every turn. You'll never win your case simply because you have the law and the facts on your side. To think so is naive. It's not that way now. Never has been that way. And now they want you to think it's that way because they don't want you to know how it really works. The way it really works is you will only win your case if you have the politics on your side. And all politics is local. And all politics is money driven. These are the rules we need to work from when we're looking at filing suits against especially public officials. Whatever claim you make, they're going to have to fight the claim. And in order to fight the claim, they're going to have to hire lawyers.
Mm-hmm.
And, you know, you think that you go to court pro se, you're at a terrible disadvantage. Well, maybe. But you also have a terrible advantage.
Mm-hmm.
If a lawyer files anything you don't like or anything wherein they make a statement that's not accurate,
mm-hmm.
if they quote law improperly, if they threaten you in any way, you file a bar grievance against them. Pro se litigants have powers and abilities far beyond those of mortal lawyers. You can file a judicial conduct complaint against the judge with impunity. He's going to rule against you anyway. If he's honest, he won't rule against you, even if you file a complaint against him. If he's not honest, he's going to rule against you no matter what you do. But as to politics, you can do things they can't. Lawyers will never file against a judge, but you can. You can get the judge so furious that he'll go to those lawyers and tell them, you get this guy off my case or I'm going to screw you big time. He can't say a thing to you because he's forbidden to. You bar grieve the lawyers, you'll double the malpractice insurance, and they can't say a word to you about it. They say one word to you, you file a grievance against them for that. You become the pro se from hell. The only way you're going to win the case is to make a deal.
How do I learn where do I begin to look to learn the process to do that? I understand everything you're saying and understand how to practice law.
Okay, how do I learn how to do it? Okay, call some lawyers and ask them what is the best litigation guide for the state of Tennessee. Litigation guides. Now, you really don't think these lawyers know all this stuff, do you?
No.
Nah, they don't know squat. I haven't found a single lawyer who's even read our state penal code. They don't know squat. They got litigation guides. They don't make up these motions and pleadings. They go pull them out of the litigation guides. And I counsel all pro ses, do not write your pleadings from scratch. Go find a litigation guide, and you can get them. Lawyers, they want the newest guides.
Okay.
So every year or every other year when a new one comes out, they go buy it. And they wind up with these old ones hanging around the office. I had a woman in Amarillo, Texas. She was looking for litigation guides. I told a couple law firms, tell them that you got your kids, you're homeschooling your kids, and you want to give them a course in law. Do you have any old litigation guides laying around? The second law office she called said, do you have a station wagon or a pickup truck? So these are books that cost $300-400 a piece. But once the new one comes out, they trash the old ones. They want to use the latest law. You're a pro se, you don't care. So you got this seminal case law. This is the law that set the precedent. And then a year later, this other case relied on that. So now the lawyers want to cite the other case because it's the latest. Well, you don't care. You cite the seminal law. You don't care. Doesn't make any difference. It's just the lawyers, they have to show the judge they're up to date on law. So they have to have these new ones. Call around a couple of lawyers, find out what the best litigation guides are, and ask them if they got any old ones laying around. You're just studying, you want to learn law. And find a civil practice guide. They're going to have a criminal practice and a civil practice, and ask them if they have causes of action. Just talk to a lawyer about the litigation guides. Ask them what they got available. See if you got some old ones. You get them, they'll tell you how to do all of this. Most of them have fill-in-the-blank forms. A little story about that. A friend of mine, Ken Magnuson, he's my civil go-to guy. He's in an eviction hearing. He needs a temporary restraining order. He writes one, gives it to me. I look it over. He said, what do you think? It's a bunch of crap, Ken. He said, you think you can do better? I said, darn right I can. I write him up one, give it to him, takes it to the court. He wins his temporary restraining order. He comes out, the lawyer looked at it, and he said, are you a lawyer? And Ken said, no, I'm not. But my brother is. He said, did you write this? He said, I had some help. The lawyer said, this is really good. And Ken told me that. What I didn't tell Ken is I took that right out of the litigation and filled in the blanks. Here's the important part. The judge got it, and he looked at it, and he had seen this exact same form 500 times. So he knew exactly where to look. He knew what all the case law was. Boom, piece of cake. If I wrote that thing from scratch, the judge would never have read it and would just have denied it. But since it looked like what all the other lawyers wrote, he signed it without even thinking about it. Do not write your own pleadings. You don't have to learn all this law. Get a litigation guide. Look up what you're doing. They'll have everything you need right in there.
Okay.
Sorry. Okay, we had another caller from Arizona, but you realized we weren't going to get to him. Sorry about we didn't get to you. Oliver, we are out of time. This is keep us up to date on what goes on here. This is Randy Kelton, Real Bar Radio. We'll be back next Thursday, 8 to 10. Back next Friday, 8 to midnight. Thank you all for listening, and good night.